Good morning, Judge Glacier. We are a couple minutes early, but we do have everybody as well as the court reporter, and I can bring them in if you're ready.
I'm ready. Thank you, Morgan.
Good morning, Your Honor.
Good morning, everyone. And good morning, Ms. Frogner. Thank you for being with us. Let me call the case. It is Audrey West and Randy West versus Michigan Department of Natural Resources. It's Court of Claims, case number 18-236MZ. And we're here at my request to discuss a motion for protective order that was filed by the defendants, and also to discuss the future of this case. At least from my perspective, we're going to be discussing the future of this case. So let me summarize where we are on the protective order issue and where I am, so I can make this hearing a little bit faster and easier for all of us. I granted in large part, the plaintiff's motion for a protective order, which included allowing the plaintiff to have counsel or a representative of counsel present at an examination conducted by an orthopedic surgeon chosen by the defendant. I granted a protective order with regard to videotaping the defendant's forensic psychological examination of the plaintiffs. I granted a protective order for the plaintiff, compelling the defendant's psychological expert to produce raw testing data. I think that's pretty much what I granted. Did I miss anything?
No, Judge.
All right. And what I then was confronted with, not unexpectedly, was a motion by the defense to request essentially the same protective order with regard to the plaintiff's experts. What I think I have communicated in my orders, and if I haven't effectively communicated that, I will communicate it now. I think that what is good for one side or bad for one side is similarly good or bad for the other side. So, Mr. Marco, I see, first of all, absolutely no reason to refuse the defendant's request for the raw testing data. None.
Agreed.
But
I agree.
I mean, unless you want to give me some good reason that hasn't been presented yet.
No, I agree. We don't have any problem with the raw data as long as it's the way I'm assuming the raw data only applies to Dr. Sewick. I'm assuming, not Dr. Shiner or Dr. Capso, because there's no raw data for those types of evaluations. Dr. Shiner is a psychiatric evaluation. There was no psychiatric testing done other than a forensic examination. So there's no raw data for that.
Okay.
Dr. Cap, I'm sorry.
No, go ahead.
This with Dr. Capso, I'm not aware of any raw data that would be generated. I will check with him, but I don't believe any. So that's left with Dr. Sewick's. We don't have a problem with that raw data as long as it's governed by the protective order, and it would be provided to the state's neuropsychologist expert under the guidelines from the publisher. So we don't have a problem as long as it's a protective order. They can have that, no problem. But I know that from past experience, the neuropsychologist will require a protective order from the court in order to give that raw data. I don't think there's an objection to that, Adam, if I'm wrong.
Well, I'm assuming, Mr. DeBeer, that everything you guys do, you can just do it mutually, because I would assume that your expert will require precisely the same safeguards and guardrails on the data as Mr. Marcos. Is that fair?
That's correct. I think I should note that during the past 30 or so days, it's been clear that defendants will unlikely be able to retain a neuropsychological or an expert to conduct a neuropsychological examination. That said, the option that I'm exploring at this point in time is retaining an expert, at least to review the report prepared by Dr. Seawick and perhaps critique that report by looking at Dr. Seawick's data. But no, under the current guidelines from the court's order, it's unlikely that I'll be able to retain an expert to conduct a neuropsychological examination.
Okay.
There's some hope with respect to the orthopedic examination that I'll be able to retain a doctor to conduct that one, but there's no need for those examinations. It doesn't present the same sort of need for a protective order that comes with the neuropsychologists.
And I can send that raw data. Your Honor, I'm sorry, I didn't mean to interrupt you.
No, I'm just going to say, whatever you're going to do, I'm going to put it on you two, the two of you, to craft a revised protective order or whatever you want to call it. The court's not going to do it for you. You're going to have to get together when this is over or whenever you want to, and put whatever language you can agree to that's consistent with my ruling today. Okay?
Yes.
That's your job. Your jobs. Okay, I'm
Yes,
sorry,
sir.
Mr. Marco, go ahead.
No, well, we can submit our raw data to his expert for review. So that's no problem. Dr. Seawick will send it directly to his expert. And so we'll work on that. That's,
Okay. All right.
I'm not going to die on this hill. I'm fine with this. So I understand.
Okay. Well, I hope you're not going to die on the next one either, because here it is. I've been around a long time. I litigated for a long time. I know Dr. Seawick. I've used him as an expert. I know Dr. Shiner. I've used him as an expert, and it doesn't fly with me that both of those very fine experts are treaters and not forensic. So, Mr. Marco, I'm going to give you this option, which I think is very generous.
Sure.
If your clients are evaluated, either one or both, by either Dr. Shiner or Dr. Seawick between now and trial, counsel, exactly the same protective order is going to apply. That is, Mr. DeBear is entitled to videotape. Now, I'll give you one out for this, and that is you can choose one of those two experts to label as a treater if you want to. But if you do that, that person cannot see those clients again between now and trial. So that's up to you, and you two can work it out. But I am not going to accept the idea that both of them are treaters and neither of them are forensic evaluators who were retained for the purpose of testifying at this trial. That doesn't work with me.
I understand, Judge, and I understand your ruling on that. If it wasn't clear so just so you know, Dr. Seawick does do treatment. I agree with you that at the time that he examined the plaintiffs in this case, he was not acting in his capacity as a treater. He was acting as a retained expert. From a practical standpoint, I just want you to understand that Dr. Shiner, Dr. Seawick, and Dr. Capsule-Cavathis have already completed their examinations of the plaintiff. So the only potential re-examinations that would be a re-examination for a trial update. So sometimes I will have my clients.
Well,
yeah, and I understand.
And if that happens, the order should reflect that you must advise defense counsel within at least 21 days of that evaluation, so defense counsel can decide whether to make videotaping arrangements.
No problem, Judge. Okay.
All
yeah,
right.
I understand.
So okay. All right, good. This is all easier than I thought it would be. Mr. DeBear, do you want to weigh in a little bit, or are you okay with what I just said?
Well, Well, I think defendants will, recognizing the court's prior rulings and the denial of the motion for reconsideration, the defense maintains its original positions, but understands the court's order. And I don't think any additional argument is necessary from
Okay.
defendant's point of view.
All right, what can we do about settling this case? Can you guys facilitate it?
So we discussed this. I'm trying to get my I have 2 expert reports that will be helpful. I have Dr. Shiner's, and just so everyone knows, she was evaluated and Randy was evaluated prior to any of the litigation regarding this protective order. So I just want you to understand, I didn't like run out in preparation for this hearing and say, let's get evaluated real quick.
I understood that. And
Okay.
I get it.
All right, so Dr. Shiner's report, it's taking a long time. I talked to him this morning. I should have his report within 7 days. That will help. My expert economist, Barry Grant, has had he's an
I
invalid.
know all about Barry Grant. My
Okay.
husband represents him. So let me reveal that right now so we can deal with that problem. I don't know if my husband, who's, by the way, I know Mr. Marco knows my husband, but Mr. DeBear, I don't know if you know him, Mark Ronzato. And I don't know if he's representing Mr. Grant at the moment, or if he's only done so in the past. I'd have to check, but just so that you know, I mean, if the case does go to trial, that's potentially an issue.
It's not an issue, Judge, anymore. Mr. Grant's in ICU in Northwestern Hospital.
Oh, I'm so sorry to hear that.
He's
Okay.
never going to practice again. He
Okay.
can't even speak. He had multiple strokes.
Oh,
So
I'm so sorry to hear that.
Yeah.
I wonder if my husband knows. I'll have to tell him.
it was like a routine heart procedure. He was supposed to be back at work. We had a trial together in January. He's never coming back.
Oh, I'm so sorry to hear that. It's really a
Yeah,
tragedy.
it's horrible. So he's not, I have a new economist, Dr. Pranjapi. I've told him we need a report ASAP because discovery is closing in January. And so as soon as I have Shiner's report, which I should have within 7 days, not to give you too much details, I know you're busy, I will get Pranjapi's report. That will help with settlement because Mr. DeBears asked for a demand. I can't get a full demand until I have the economic report.
Okay.
Mr. DeBears indicated, and I've done a lot of litigation with the state of Michigan, that a real settlement discussion cannot take place until they file their motions for summary. And this has been my experience with the state of Michigan. So I take Mr. DeBeer at his word on that. It's not uncommon. It happens all the time for him to be able to get authority and for his client to be able to get authority. So my suggestion would be, I get these expert reports as soon as I humanly can. Mr. DeBeer goes ahead and files his motion for summary. We get a ruling on the motion for summary, and then we facilitate. We can even set up and pick a facilitator now if we have an idea on a schedule for summary, if that would work with you, Adam.
Yeah, no issues with respect to selecting a mediator. We've worked with a handful that are very good. Generally, for the record, as far as a briefing schedule, I know we have our deadlines, but if we wanted to set up sort of an extended briefing schedule where plaintiff could have, instead of the 14 days to file a response, plaintiff could have 21 or 28 and then give, an additional 7 days after that for the filing of a reply. I think that would be a good idea. And then hopefully the parties in the meantime can work and set up a date. The mediators that we like to use are very in demand at the moment. So I think if we reach out for dates shortly, we should be able to get one, I think, by the time that, we could reasonably expect a ruling on summary disposition motions.
And Adam, I'll send over a handful today that we've used in the past with the state. And then you can let me know and we can work that out without the judge.
All right.
Great. Well, you whatever you guys want is fine with me. And as Mr. DeBear probably knows, I'm not the swiftest at turning around the motions for summary disposition anyway. But I'll do my best because in this case, I know that you'd be facilitating or mediating or whatever you're doing. So it gives me added incentive to try to get the motions for SD done. So do me a favor and work out the dates. Whatever you guys come up with is going to be fine with me. And just send me, if you would, send me an order, either one order that encapsulates everything we discussed today or two orders, however you want to do it. I'll sign them and carry on. I'm glad that we've got so much agreement going on in this case. So that's
Took a
very,
couple of years, but here we are.
yeah, here we are. Anything else we should be paying attention to?
Not from our side, Judge.
And nothing from defendants either. Thank you, Your Honor, for conducting the hearing this morning.
And thank you both for showing up and helping move things along. So great. I'll look for the order or orders and we'll take it from there.
Happy holidays, everybody.
Thanks. You too. Thanks a
Same to
lot.
everyone.
Bye-bye. Ms. Frogner, do you need anything? No?
No, I'm
Very
good.
good.
Thank
Thanks a
you.
lot. Bye-bye.
Okay, bye.